Hello and welcome to another episode of MondAI BAIgel. I'm Michał Jackowski, and today we have a very special guest with us, Robert Plotkin. Robert is a patent attorney specializing in patent protection for AI and other software-related inventions. He's also a co-founder at the boutique patent law firm of Blue Shift IP located in Cambridge, Massachusetts, specializing in software patents for over 25 years. Today we are going to dive deep into his new best-selling book, AI Armor, and explore how AI companies can strategically use IP to protect their innovations and drive business success. Robert, it's a pleasure to have you on the show.
Thanks, Mikhail. Thanks so much for having me.
Um, in your book, you talk about the intellectual automation revolution. Can you explain what this term means and why it's significant for AI companies?
Yeah, I use it to contrast it with the term industrial revolution. People have talked about there being several different previous industrial revolutions, and they all involved automation of production and distribution of goods. Think about the steam engine or the combustion engine. Those enabled us to manufacture and distribute physical products. Even the information age you could think of as streamlining, automating, speeding up the process of producing and distributing physical goods. What I'm talking about as the intellectual automation revolution brought about by AI is the actual ability to create, design, come up with ideas for new types of inventions, machines, software, and for artwork, even for writing. So the current stage of automation powered by AI is moving up the intellectual chain, so to speak, and automating higher and higher levels of the creation process. And that's where we stand now. We finally have technology that's able to start encroaching on the types of creative work that before was really only capable of being done by humans.
But it's quite unique for a lawyer to write a book about automation of operations by automation revolution. What inspired you to write this book, and what is maybe the key message you hope readers take away from it?
Yeah, well, before I was a lawyer, I was a computer scientist. So I'm a computer scientist and an engineer by training. So I have my feet in both worlds. And even as a lawyer, my role is as a patent attorney to obtain patent protection for new inventions. So I work with innovators, inventors, entrepreneurs, high tech companies all the time. So it's yet another way in which I have my feet in both worlds, in which I've been witnessing this and other types of automation for decades. And that's why I think as a lawyer, I've been able to see this happening. And because my field of patent law is really, you could say, is the law of invention. It's the field of law that provides protection for new innovations. As artificial intelligence is automating the process of creating new innovations, it's having really significant impacts on patent law and is raising a whole bunch of questions really about how to apply patent law when technology is starting to be able to automate that process.
You describe also in your book the mind process as a strategic approach to IP protection. Can you elaborate on this a bit more? I read the book and it was extremely interesting.
Yeah, this is really a strategy for obtaining the right type and the maximum strength of intellectual property protection for any new innovation in AI. So if any of your listeners are developing new types of AI technology, new techniques for training models, for using machine learning models, for example, to solve new types of problems, this mind process, it's a four-step process. M stands for mapping. I stands for identifying your strategic business goals. N is navigating the intellectual property landscape, and D is driving successful business outcomes. So the first step is really the key. Again, if you're innovating and you've developed some new improvement to artificial intelligence technology, the first thing to do is to map out that technology, meaning develop a solid understanding of exactly what it is you have developed and what is new, innovative about it, and what about that technology gives you a competitive advantage. What is it that's going to draw customers to you rather than your competitors? You have to start with that really solid mapping of your technology. If you don't, and you just jump into obtaining patents or keeping what you have as a trade secret, for example, or copywriting some of the code, you're very likely to either underprotect, meaning fail to obtain intellectual property protection that's really valuable for you, or to overprotect or get the wrong protection. You might get a patent on something that's not really valuable to your business. And so the mind process systematically steps through identifying what your technology is, what your business goals are. For example, if you're a small startup and your goal is to build up and within a few years get acquired, that's one business goal. And a certain type of intellectual property protection will help you achieve that goal most effectively. If instead you're looking to develop the technology and license it, meaning charge a fee for other companies to use the technology, that's a different goal. A different type of intellectual property strategy will be most applicable to you. So this mind process steps through identifying your technology, your business goals, and then identifying and obtaining the most effective, appropriate type of intellectual property protection based on your technology and your business goals.
It sounds like a very good initial step of preparation of AI governance strategy or AI policy even in the firm. How big the firm should be to be able to adopt this mind process?
Even a small firm can use it. If you're small and you have a relatively incremental or small innovation, then the 4 steps can be done in a fairly compressed form. They don't have to take a lot of time. When working with someone like me, we might be able to step through the mapping and the identification steps, the first 2 steps, fairly quickly because of the small scope of the innovation and the business. For a bigger business, if you've got a really radical new technology and it's something that you're going to build a big product line based on over the next 5 years, well, then it's going to require more time to step through the mind process. But it can be adapted really for any size business. It's just that we may take less time on some of the initial stages if you're smaller.
Okay, very interesting. I'm an EU citizen, a EU lawyer, and European approach to patenting AI and software. How is it in US? There are some misconceptions about patenting AI and software. Can you elaborate on this? Explain how is the US approach to patenting AI?
Yeah, well, let me just first say that in general, I find there is often a misconception. People often believe that software in general cannot be patented at all.
Yeah.
And that is a real misconception. My firm, Blue Shift IP, our tagline is software patent experts. Almost all we do is obtain patents for software all the time. I've personally been doing that for over 25 years in the US. So software is definitely patentable. And I start by pointing out that misconception because there's a lot of companies who believe that misconception and as a result, they create some innovative software. They don't attempt to patent it because they don't believe that it's patentable. And then they fail to obtain patent protection that could be really valuable for them, whether it be to stop a bigger company from using that technology, or it might mean that they forego licensing revenue. Maybe they don't increase the value of their company when they're going to get acquired. Any of those reasons. So the first thing is that software in general can be patented, and AI is one of those types of technology that can be patented. You need to look at exactly what you've developed. Normally, you in the context of software, including AI, you will patent methods. So for AI, that might be a method of training a model would be a really good example of something that could be patented if it's new and it's different and it trains the model more effectively or efficiently or produces a model that's more useful than other models. In the context of AI, you might have a method for applying or executing a model, performing inference on a model that's more effective. You might have right now, a very active field of work is on reducing so-called hallucinations by models, right? Verifying the outputs, improving the accuracy of the outputs. Any of those methods are things that can be patented in the US. You do need to make sure that you have developed the technology to an extent that it really works. And then in the patent application, you have to provide enough detail about how the invention works. You can run into problems if you file a patent application and you only provide a very general, high level description of the invention and you don't really explain either how it's different from what came before or how to really make it work. For either of those reasons, your patent application could be rejected and it might be hard to overcome the rejection. That's why we focus on writing really thorough patent applications that cover the technical details and that also describe at a high level what's new, useful, different about the invention. And so it does take some real experience with software patents to write them and obtain them in a way that the patents that you get are strong, broad enough to give you real protection and defensible.
So maybe two more specific questions about this field, because we know that we are lacking transparency in the field of generative AI. How can I check the history if my innovation is really novel when, for instance, OpenAI doesn't provide in a very transparent way how they manage to do it? It's just the example.
Yeah. I mean, it is a hard problem, but one way people often do this now is by performing experiments and checking the results. So
Okay.
even if you can't see, let's say, how OpenAI's models are working inside, you can give them inputs, right? And you can look at the outputs and you can see if you're asking it a question, you can see how good the answers are to those questions. And then if you've trained a new model, you can do the same thing. You run experiments where you provide inputs to your model, you look at the outputs, and then if you run thorough enough experiments and you can demonstrate that your model consistently, let's say, produces better results than another existing model, that's something you can use as evidence in a patent application, for example, to demonstrate that your model is new and innovative, even if you can't show how the model works internally, and even if you can't show how the previous model, like OpenAI's, works internally. It's very much analogous to how things work in chemistry. You know, it's strange, right? You perform experiments, even if you don't know how the chemical or molecule or other material is working, you know what it does, and you can show that experimentally. And that's how the direction things seem to be moving in for AI models now, where you can't analyze how they work, but you can show what they do.
Okay. And my second question, trade secrets play a crucial role in protecting AI innovations. How do you harmonize it with patent protection or applying for patent protection when you have to describe your trade secrets?
Yeah, it's a great question. I do talk about it extensively in the book because it's always important when you develop some AI innovation to evaluate early on whether you want to patent it or keep it as a trade secret, or perhaps whether if there's multiple components of that AI system, you might want to patent some of them and keep other parts as trade secrets. And very often, it's a good business decision to keep at least some of what you've done as a trade secret. One of the reasons is what you just said. Very often, even if you make an AI model commercially available, like in the case of ChatGPT, we can all use ChatGPT, but as users, we can't look under the hood. We can't really see how the GPT model is working. And so if you've developed such a model, and you want to make it available for public use, sell subscriptions to an application that uses the model, you might still find it valuable to keep the model or the way you trained it as trade secret so that other people can't create similar models using your training methods and compete with you. So very often it's valuable to keep some AI innovations as trade secrets. But there are also benefits to patent protection. One is that a patent protects you if someone else independently comes up with the same let's say, training method as you, independently of you, even if they didn't copy you, they would still be infringing your patent. So that can be a valuable reason. First, a small and growing company that's looking to be acquired by a bigger company in the next few years, having one or more patents, they can be very valuable assets, which can be attractive to a bigger company to acquire for use against its competitors. And very often those patents are more attractive for use in an acquisition than trade secrets are. So there's a variety of trade-offs. Again, I go into much more detail in the book that really have to be evaluated on a case-by-case basis to decide whether patent or trade secret or some combination of the two is the best for your company based on the technology you developed and what your business goals.
Maybe you can share one real-world example where a strong IP strategy made a significant difference for AI company. Is there any?
It's still early now. I mean, I have a client, Zapata AI. They just went public. They're a small company. They're only about 6 years old. They are a pure generative AI company. They just got listed on the NASDAQ, and their patent portfolio was a really significant part of their value that distinguishes them from other growing generative AI companies. There's thousands of generative AI companies out there now, and many of them have no patent protection at all. This client of mine has a very significant growing international patent portfolio. I'm not going to say it was the only factor, of course. Their business is very strong, but that patent portfolio can play a really a valuable role. And in the history of software companies generally, there's many examples in which a strong patent portfolio helped the company or in which a lack of a patent portfolio really hurt the company. RSA security is a really famous example where RSA got a patent on their RSA encryption algorithm early on. They ended up licensing that patent and earning tons of money over 20 years from licensing revenue from that patent. Very famously, on the day the patent expired, their competitors threw parties because they weren't going to have to pay licensing fees to RSA anymore. And just think about all of the companies over the years who were really innovative, who were really ahead of their time, but who got foreshadowed by other companies, but where those innovative companies didn't have patents. It's often said, we talked about that Steve Jobs took this trip to Xerox PARC in the 1970s and saw graphical user interfaces with a mouse and windows, and no one had been doing that before. And he said, wow, that's amazing. And he incorporated it into the Lisa and the Macintosh. Well, Xerox wasn't obtaining patents on that technology. You can only imagine how the history of the industry might have been different if they had had patents. Maybe they could have either been the initial dominant player, or they could at least have licensed their technology for use in the graphical user interfaces that we all continue to use now, decades.
Yeah, but given the rapid advancements in AI, how do you see the future of IP protection in this field?
I think, again, you look at just how intense the competition is, whether it be among small companies. There are small AI companies sprouting up every day, all the time. And a lot of them, to be honest, don't have much that distinguishes them from each other. And so there's not much that they have to do to really have staying power. Intellectual property protection can be one of those things that can distinguish you from the competition. And that can, again, if there is competition, if you have a patent on some aspect of your AI technology and competitors who are your peers pop up who are using that patented technology, you can either stop them or you can get licensing fees from them. What most small companies are more interested in is using IP protection, including patents, to get acquired or be able to block bigger companies. Look at just the small number of massive companies now that are dominant in the AI space. In the book, I call them big AI: Microsoft, OpenAI, NVIDIA on the hardware side, of course, Google, Amazon. There's a small number of these giant companies that are actually being extremely innovative for large companies. and that are dominating the market share and the mind share. Just think about it. When people talk about AI, sometimes people use the term chat GPT sort of interchangeably with the term AI. That's how dominant it's become in people's minds.
Mm-hmm.
Well, if you want to get acquired by one of those companies, or license your technology to one of those companies, or be able to block one of them from just looking at something you've done that's innovative and incorporating it into their own products, you'll need intellectual property protection, because you're not going to have the market or business leverage to stop them from doing that. So in many cases, IP protection, especially patents, are the only thing that a small company has as leverage against a much bigger dominant player. And that's going to be increasingly true with AI, and particularly because of the speed at which innovation is happening. It's become increasingly important to get patent applications on file quickly, because it's really the filing date that's important. And so the pressure is on to get patent applications filed quickly so that you can use them for all of these reasons.
You answered my last question, which I wanted to ask you about the advice you would give to AI companies when they should start and how they should start and why they should start developing their IP strategy. But maybe you can give us one last most important hint. What would you suggest ending this podcast? Just
Yeah,
one most valuable insight.
which is start investigating IP protection early. Even if it turns out that you're not going to pursue patents, for example, at least investigate it and do it soon, because of how rapidly innovation is happening. I mean, we've all seen it since the launch of ChatGPT. There are new developments, sometimes really significant ones, every week. I mean, sometimes multiple times in a week, you'll see really big improvements in all of the big models that are out there. And the big companies like OpenAI and Google and Microsoft are often competing with each other to leapfrog each other with their new announcements, right? About multimodal models now, or agent-based technology. It's happening so rapidly that if you wait months to file a patent application, you may very well have missed your opportunity. Again, because patent protection is secured based on the date on which you file a patent application. So if you develop something new now, for example, you don't file a patent application, and then Microsoft announces the same type of innovation a month from now. Well, that announcement by them will essentially block you from filing a patent application afterwards. So I'm not trying to engage in a scare tactic. It's just that I've been doing patents for over 25 years, and software has always developed rapidly, but I have not seen this pace of innovation in the whole time in which I've been in the field. So that's my main advice. At least investigate it soon, because then if you do have something that you want to patent, you can get something on file quickly and secure the filing date for the protection. That's my main piece of advice.
Perfect advice. Thank you so much, Robert, for sharing this advice and other insights with us today. Your book, AI Armor, is an invaluable resource for anyone involved in AI innovation. And to our listeners, be sure to check out Robert's book, read it, and follow him on LinkedIn for more insights about AI and intellectual property. And don't forget to subscribe, give us thumbs up. Stay tuned for next MondAI BAIgel episode. Thank you, Robert, for being here.
Thank you so much for having me. I really enjoyed it.
Thank you. Bye-bye.